All right, well, good morning, everyone, and welcome to our May meeting for the Virginia Caregiver Coalition. We are going to continue our breakout room that we started at our last meeting, where we just have 5 minutes for everybody to introduce yourselves, your organization, your caregiver status, and then maybe how long you've been with the VCC or why you joined the VCC. And yeah, so Nick, if you want to just go ahead and put us into our groups, and we'll just go from there. I think everybody's back now. Yes, Nick. All right, awesome. So before we get officially started, our Vice Chair Juliana just wanted to remind everybody to please fill out our survey at the end of today's meeting. We are going to be using this information and the feedback that we gather to improve our educational series and to use it to guide the direction of the VCC in the upcoming year. We've kind of said it before, but we really want this group to be what you guys want it to be. And so that is how we're going to be gathering that information. So please fill that out. And I think the link, Juliana just put that into the chat. So, and we'll give you all some time at the end to fill it out as well. So just a few quick announcements before we get into our educational presentation. So if you are the caregiver of someone with chronic pain, fatigue, or other symptoms, then researchers at the University of Albany SUNY are seeking volunteers for a research study to understand the experiences of caregivers for individuals with chronic symptoms. And the goal of this study is to understand what factors should be considered when supporting caregivers. I am assuming that Nick will be sending out this information with the follow-up email on how to get signed up for that if you fall into that category, but sounds like a good opportunity to share your experience if you fit into that category. The next announcement is that the Central Virginia VA healthcare system has a goal to establish new community coalitions for veteran suicide prevention and support existing coalitions who have missions aligned with the VA's community-based interventions for suicide prevention program. The VA wants to work with communities on suicide prevention, and they hope to integrate the VA's suicide prevention strategy into existing local efforts to serve our veterans and the greater population of the community. This community-based suicide prevention initiative is to ensure the health, safety, and well-being of our veterans where they live, work, and thrive. And they are looking for someone who would consider engaging in a conversation on the best ways to collaborate. So if that sounds like a category that you might fit into, if you work with veterans at all, I believe that Nick is going to be sending a program brochure along with the contact information for the contact at the VA for that program. Is there any other announcements from our membership? Anything that anybody would like to share, or any announcements in terms of things that are going on around the state?
Real quick, Emily, Kristen actually just put in the chat box that this month, May, we celebrate Older Americans Month, and the theme this year is Aging Unbound. So a shout out to Older Americans Month.
Yes.
I can share that. Just an update on the DARS side. I don't think that Kathy or anyone of me will be attending today, but it has been determined. I don't know if you are familiar with the Aging Services Work Group that was created with I can't remember his name, but a member of like the Virginia General Assembly or the Senate, and he was working with some of the executive directors and other stakeholders at like the AAAs and stuff, and they've determined that DARS will be creating a separate division, and that the division for community living, which the Department for Aging currently sits in, is going to be split out into a separate division. So community living and aging are going to be separated, and guardianship and APS are going to be moving to community living, and then we are just going to be aging programs. So it's kind of an internal restructuring.
Okay.
But that's kind of what's going on there. And Marcia Dubois will actually be moving over under community living, and we will be looking for a new deputy commissioner of aging. So
Okay.
fun politics.
Yeah, I would say so basically everything's staying the same. It's just kind of just an internal restructuring is what you're saying.
Yes, the ultimate goal is to elevate aging.
Okay.
That was the whole point of the work group. And
Okay.
they determined that this would be the best way to do that. The other argument was splitting DARS out again and cleaving off the Department of Aging and Rehabilitative Services to be two separate agencies, but they logistically they decided not to go that way.
Gotcha.
So,
Okay. Well, thank you for the update on that. That's definitely very interesting. We'll have to keep an ear out and an eye out for when all of that transition is happening. Any other announcements from the membership?
I have something I'd like to share from the governor's conference. We had a breakout session for those assisting caregivers in a professional role, and we hope to keep that going. It can be as a committee to this group or something separate just to touch base on occasion, maybe quarterly, to share any issues or concerns or to support each other. So if you would like to be in that, please put your information in the chat and I'll add it to the list.
All right, thank you, Dee. Anything else? And of course, as always, if you think of anything after the fact, please feel free to send that over to Nick and he can include it in the follow-up email to the entire membership list. So in terms of old business, our work is still continuing on getting other committees, the subcommittees staffed and running. Unfortunately, Nick was unable to get a list and make contact last month, but we are still continuing to work on that. So just again, be patient with us and keep your emails open. We should hopefully be getting that done by our next meeting and get those ready to go for everybody to start participating in. Any questions about committees or anything like that? So unfortunately, Donna couldn't be with us today, but I believe our Vice Chair Juliana is going to go ahead and introduce our presenter for this month.
Good morning, everyone. Today we have Rory Clark, who is an elder law attorney. Rory is a native of Virginia with deep roots in his community. He has more than 30 years of experience practicing elder law, estate planning, asset protection, Medicaid planning, Veterans Affairs, and special needs planning. Through his personal journey, Rory not only understands the complex legal issues involved as a professional, but also the intense emotional issues as a caregiver. Since 2000, he has held an AV preeminent peer review rating by Martindale-Hubbell, meaning he is nationally recognized as a lawyer with the highest levels of skill and integrity and has reached the height of professional excellence. Rory has also earned an AVV Superb rating of 10 out of 10. He is an accredited attorney for the preparation, presentation, and prosecution of claims for veterans benefits before the Department of Veterans Affairs. He is admitted to practice in Virginia, Maryland, and DC. In 2019, Rory authored the Family Estate Planning and Elder Law Guide. He is sought after as a frequent public speaker on issues of elder law, special needs, and taxation. A longtime resident of Loudoun County, Rory was reappointed vice chairman of the Loudoun County Zoning Board of Appeals in 2020 after many years of serving on the board. A member of the National Association of Elder Law Attorneys, in 2021, Rory was elected to the board of directors for the Virginia Academy of Elder Law Attorneys, where he serves as chair of the Member Relations and Commissions Committee. In 2022, Rory was designated as one of the 2 qualified master counselors in Virginia. Welcome, Rory, and thank you for being with us today.
Unmute myself. Thank you, Juliana. I appreciate that. And it's always a little embarrassing to hear somebody introduce you. that last part about being designated one of 2 master counselors in estates and trusts in Virginia is actually an old stat. There are now 3. The third one is my partner. So 2 out of 3 in the entire state are here at Legacy Elder Law. So if everyone will bear with me, I'm going to just dive right in, share my screen, go through this presentation of things that is sort of a kind of a survey course like you may have had in college, talking about some really interesting points. It's not going to be a too terribly deep dive on any point. It will be trying to cover a lot of wide range of things. If anybody has questions about any of these things, you're perfectly welcome to reach out and talk to us and get more information about it. And if you are with an organization that has a community that might benefit from this or some other informational stuff, this is what I do, spreading the word, spreading the gospel. And if you'd like to have a presentation, this presentation or another one that we may have, whether it's special needs or Medicaid planning or veterans planning, please reach out to us, and I'm happy because all I have to do is walk across the hall, come to my Zoom room, and I can talk to anybody, in that 3-state area. Okay, so let's see if I can open this up. And we'll get started. And we're going to have questions afterwards, so please feel free. I guess it's a small group, so we can do them verbally. Just unmute yourself. In order to keep things efficient, let's try to hold questions to the end. If people need to move on, that'll allow them to do it, but it won't delay the presentation. Does that sound okay, boss, for us to do it that way? Okay, great.
We are in presenter view, just to let you know.
Excellent. Great. Thank you. Okay. So, as I said, this is a sort of a survey course, top 10 hits about legal facts. That's an inside joke in court. There's the law and there's facts, but there is some law out there that has, that exists. And the fact that it exists is sometimes things that people miss. And so the point here today is to focus on some of those things that are lesser known or unknown or confusing, maybe misunderstood. So I'm not able to advance. Nick, I wonder why.
So what
there
we're
we go.
seeing is
I just have to use a different button.
What is like the presenter view that you would see where if you had notes and stuff, not just
you're seeing presenter view?
Yeah.
So I'm seeing the whole screen. That's bad.
I think you just have to share the presentation instead of like your screen.
How do I do that, Nick?
So under sharing,
like I'm going to stop sharing.
When you go to share, it'll say share screen, and then it'll say which one, and you should be able to just share the presentation. Because if you're working on multi-screen, one screen will be the presentation and the other one will be like the presenter view.
Yes, I am on multi-screens. So I'm going to right-click on my presentation here and see what it says. Not given an option. Advance, portion of screen, computer audio, contents from second camera.
Rory, I think you might be having the issue that he presented with us. So probably if you go back to how you did it for our audience, it might work.
And just use the bigger screen.
Yeah, I think
Let everybody see the side presentation.
Up to you.
Yeah, is that everybody can see the big slide there, can't they?
Mm-hmm.
Yeah, so let's just do this and the spoilers. You'll see the spoilers on the left-hand side. Okay, is a small intimate group, no problem. All right, so we're going to talk a little about this today, that one of the things that you will be becoming aware of, I think, in the next few years is that in the law side, there is a trend towards multidisciplinary practices because the interaction or the interplay of care and care coordination with the law is becoming harder and harder to separate them. And creating a plan, I'd like to say to people, is not like taking a snapshot or a photograph. All of you all know that, right? What is perfect for today or this month may last for 24 hours or 30 days or 6 months or, indefinitely. And so a key part for the lawyer to try to help people make a plan is to have the best information we can about how things are going to progress in terms of functional limitations and life function abilities, so that we can master resources and benefits and living arrangements and support, so that we don't run out of money too fast. And that we don't drive our caregivers insane in the process. So we have formed, and this is starting to happen around the country. Some law firms are starting to provide licensed clinical social workers within their own firms. We actually have a separate entity that is a care agency, GuideWISE, that can diagnose and can provide care. We just recently have been approved so people can get reimbursement from their long-term care insurance companies to help underwrite our costs. And we will come on board and be advocates for people at their nursing facilities or at schools if they're younger people. We'll help coordinate getting the house cleaned or the grass cut. We'll go to the dentist appointment to try to make sure that there's a good translation of what's happening in the real world, to the professional. And we communicate back and forth so that the lawyers know exactly what the path is likely to be, or get better projections, so that we can make sure that the legal plan, fits for that. It's all about the continuum of care. Okay, so now I go to my other buttons. So the first thing I want to point out is this is something that's really, really obvious to those of us who are elder law attorneys, but to so many other people, it's just they don't even know that there's a difference. When I started practicing in the 1980s, I was what you would call an estate planning lawyer. I helped people with end-of-life issues. Yeah, we did powers of attorney, but mostly it was preparing wills or helping them avoid the probate process when they died. Frankly, we spent a lot of time helping people avoid the federal estate tax, but these were all really focused on end of journey. There was no such thing as an elder law attorney. There certainly wasn't a group of them back in the 80s when I started practicing. Well, good news is that over the years, that estate tax problem has become more minimal, but a new elephant has entered the room, and of course, it's long-term care. This is what you all are dealing with. And lucky you all, a new breed of lawyer emerged to address this new situation. Elder law lawyers, I like to say, are not death planning lawyers. We're life planning lawyers. Our goal is to make sure people actually have something left when they die to leave to their families, so that it isn't consumed inefficiently or inappropriately or wasted because people aren't aware of the challenges that they're going to face during a lifetime or a retirement, of needs. So our focus is not on the gruesome end, but helping people focus on positives and resources to our focus, I always say, is to empower people to live with the maximum amount of dignity and independence so that they control their own lives and control their own destinies. And there's not a lot of law in that. It's about quality of life. So we focus on the decade or two before people pass away on quality of life. Sure, we do the end of life documents as well, because we are all going to die eventually, but the real focus is before. And the reason I make this point is that when you talk to professionals, if they say to you they're an estate planning attorney, they're probably cluing you in that they really focus on those very serious needs at end of life, But many of them, in my experience, have no more clue what life planning lawyers or elder law lawyers do than I know about how to patent a nuclear power plant. I mean, I'm aware of the concept, but it really is a different focus. So that terminology is important. The other thing I'd like to point out about it is we collectively, because we have to truncate things to make it a little bit efficient, when you hear someone say they're an elder law attorney, they're also telling you they do special needs. We may be dealing with infants and newborns and kids who are approaching 18, or people who are, very young, just starting out and facing a lifetime of special needs. But the body of law dealing with disabilities and benefits for people with disabilities tends to be the same regardless of age. You just can't fit elder law and special needs law needs care on a business card. So elder law actually means special needs law too. Okay, so one legal fact that I want to point out to people that we see particularly in dealing with seniors is, this once a year, we've got this open season on people's, Medicare plans. And you can't watch television for 5 minutes without seeing multiple advertisements from very famous people telling you to come and sign up for their Advantage plan, which basically sounds like if you sign up for this, you're actually going to get a check back, get meals delivered, and people to drive you everywhere, and vision care, and it's like, holy gosh, this just seems like a miracle. Well, the point that people need to understand that many people miss is that, like anything else, it's a question of costs versus benefits. And the point of the Advantage plan is that it allows people to opt out of a set basket of benefits and try to customize those. Yeah, you can get meals. Yes, you can get a certain amount of care. Yes, you can get some money back off of the deduction from your Social Security, but you can't get them all at the same time. Some Advantage plans require a much higher premium. Some actually are cheaper than the standard, and you do get a little bit back. I think stories are an easy way to help convey the importance. I want to tell you a story about a client of mine a few years ago who thought that he had just found the dream in terms of getting care managed when he opted early to mid in his retirement for an Advantage plan. He was of very modest means and had a very modest income, but as he was starting to age, he was needing to see more and more specialists. And what was killing him was his co-pays, which he had to pay under his regular Medicare plan. So he looked into it, and he found that there was an Advantage plan where he could see his doctors and not pay any copay. And he said, awesome, that's great. And for a number of years, he won. He got the access to the doctors that he needed, and he didn't have to pay any copays, and it saved him several $100s a month. And on his budget, that was, real money. He never asked the question, what benefit was he giving up in his package in order to get a package with no copays? Well, we found out when he had a crisis late in life. Not only was he of modest means, his family was of modest means. He had one daughter, he had no wife anymore. His served food at an elementary school, so she had a very modest income of her own. He landed in long-term care, or actually in a skilled nursing unit. And instead of having the traditional Medicare 20 days full pay plus half pay up to 100 days of total care, he found out that where the insurance company saved money to give him no copays was by reducing his nursing home benefit. So he went from some coverage for 100 days in skilled nursing to 7 days, period. I don't know anybody who goes to skilled nursing for 7 days. If you go to skilled nursing, if you only need 7 days, it's because you died before you got to day 8. And of course, it was too late to make the change. And the family came to me saying, this can't possibly be. How could anyone let a person make a decision like this? And the only answer is, it's America. You're allowed to choose the plan that you want. You need to look into these things. So this is sort of a warning. It can be great. You just need to make sure, like every other decision in your life, that you balance the cost versus the benefits, and reevaluate every year, because these plans can change. In another example, I signed my father up, who had Alzheimer's, for drugs under Medicare. And I found a perfect plan. There's, you can go online and you can put in the medicines that he takes, and you say, sort for me and tell me the lowest cost on an annual basis. And it gave me a plan, and I signed up for it. And I'm in the business, and I let him just automatically roll over the next year. And guess what? The insurance company during that year took his most expensive drug and took it off their formulary. I was totally asleep at the wheel. The next year, he automatically renewed. We were locked for a year, and I was paying $650 a month in copays for that one medication. And I'm humiliated that I should know better. So don't do what I did. Pay attention to these things, because they do change. If you make a change, make sure you understand it, and make sure you understand what changes occur in your plan from year to year. Okay, let's talk about conservatorships and powers of attorney. I probably once a month get a touch involving a family situation where there's somebody who feels that they want to help from a personal standpoint, somebody in the family, who's in a crisis or who needs assistance or is aging, but they are unwilling to touch the situation because they have been told that they are personally liable for the bills or the costs that are incurred in providing care for this person. Let's just take a horrible example. Oh, if my aunt has to go to a nursing home, and it's like up here in Northern Virginia, $18,000 a month, I got to go tell my husband, honey, I just signed us up for $18,000 a month of liability. It is not true. Whether it's a court-appointed conservatorship or whether that person voluntarily shares authority with you under a power of attorney, your job is to help them. Just like me, if you hire me, right, I'm not responsible for your bills. I may impact the size of your bills, but I'm your agent. If I apply for a benefit or negotiate for your ability to be into a facility, that's working for you, but the bill always belongs to the principal, okay? And this is a frightening thing, because this can be a fact that it's not true, but when people hear it, they just shut off. They don't listen to anything anymore, and they just say, well, we've got to do another solution. And many people end up falling on the public guardian, and this is not the optimal situation, for many folks, okay? So conservators who are appointed by the courts do need to file annual paperwork with the courts or with a court authority called the Commissioner of Accounts to report on what they did with their ward's money. And the ward, if the is for the cost of that accounting, but reporting that you've been honest is with the other person's money is different than saying you're personally responsible for paying the bills. Okay. This is another impact of the financial consequence, and I'm a little bit embarrassed to tell you that there has been a new law, a well-intentioned law put on the books in Virginia just in the last year that we are very concerned about. And when I say we, I mean the Virginia Academy of Elder Law Attorneys. Some of you probably, I bet more than just one or two of you saw a movie on Netflix a couple years ago called I Care a Lot, I think is what it was called. And it was fundamentally based on a true story about how the guardianship process works in Nevada, where strangers who are not attorneys with no ethical regulation can actually suggest to a court that a stranger needs a guardianship, get themselves appointed. And the personal story in that movie was actually pretty spot on to the actual facts of one case that became rather notorious. Now, it's Hollywood, so they had to mix in a dwarf Russian mafia guy, to make it exciting, and a couple of attractive women who were attracted to each other to, get the guys to watch. But all of those were distractions from the fact that there was some really very frightening stuff that's happened. More to the real world, and that stuff doesn't work. That stuff that happened in Nevada can't happen in Virginia, Maryland, or DC. But there has been a concern, particularly with public guardians having to, with a list of hundreds of cases that they have to watch. Has there been adequate attention paid to wards by the people who are put in charge of their care? And so a well-intentioned law was passed requiring a number of things that haven't been required in the past. Face visits on a regular basis. The one, and we could talk for a long time about those, and in fact, some of them may cause a financial, impact. Getting what do you do if you have a ward who can't pay for certain care, or if the ward is remote, how do you pay for getting to face-to-face visits? But the one that I want to point out that's really the canary in the coal mine is the Virginia General Assembly included a provision in the annual reports section that says everybody appointed a guardian in Virginia must report publicly, not only to the court, but to social services, a piece of paper that goes into a file that's publicly accessible to anyone, where the guardian must report their personal view about the prospects or prognosis of the ward in the future, specifically list diagnoses, some of which could be quite embarrassing. And for lawyers who are guardians, this is a real problem because they legally have an obligation not to violate confidences of their clients, but any just plain old ethical guardian should have a real problem about disclosing private information. It's our view, or many of us in VELA, that this statute actually requires guardians to violate their ward's federal HIPAA rights, the privacy rights. That's all those papers you have to file every time you go to the doctor. Who can they share information with? This new statute requires you to disclose that information and put it in a public file. And I'm going to say the worst cases I have are wards who have paranoid schizophrenia. They are not really interested in having anybody in the street being able to walk in and get their file about, the reports about their conversations with their psychiatrist or their psychologist. How do we deal with this? Well, we are getting a lot of, as far as I know, there's been maybe 5, 6, 7 cases of this coming before judges. We've handled 4 or 5 of them in our office alone, a majority of them that I'm aware of, where we brought this to the attention of the judges, and we have found a way to allow the judges to move forward respecting the rights of the ward. And what we do is we customize and craft the order for our guardians. We've gone in a couple of times for guardians who are very worried. They've already been guardians for 10 years, but they're worried about next year's report. So we've amended their guardianship orders to find a way to alleviate the obligation to violate these HIPAA rights. If you don't do that, and you get caught in this and you refuse to report that information, if you come back up on a contempt charge or to the court's view, the only way you're going to get out of it is by convincing the judge that he has to rule this statute unconstitutional. And I can tell you, practicing law for 35 years, I have never once seen a judge rule an act of the General Assembly unconstitutional. That is not what they prefer to do. They want to see another way to get around a hardship. They would like to see VELA petition the General Assembly to balance these rights a little bit better. But in the meantime, people need to be aware that they have to look at their order and look at the new reporting statute before the report is due and they may need to go back to court and get an amendment so that they can protect their ward's privacy. This also drives the question. I have had several people say, if I can't get this order amended, I will not violate my son's rights. I will resign. And what does that mean? That means another person going on the public guardian list, getting, limited resources for care. Okay, so that's a new legal fact that I really want people to be aware of. The best way to avoid a problem like this is to deal with our clients or individuals before they lose capacity, so that they can voluntarily set the terms of how they get personal or financial assistance. You all, I'm sure, are very familiar with the two main tools we use for this. This isn't estate planning or Medicaid planning per se, but these are the tools where I could voluntarily name someone like my wife or my son to handle financial matters for me, or handle healthcare decisions for me, or specify what I want done under certain circumstances. This also connects to the difference between estate planning lawyers and elder law lawyers. It's not because I'm smart, but if somebody comes in with a power of attorney, it's not unusual for me to see that a conventional estate planning attorney has given them a power of attorney that's 5 or 10 pages long. And it's not because it's a bad power of attorney, it's because that traditional estate planning attorney wants to give them a balanced document that's useful, but doesn't open them up to a lot of risks in a world where identity theft is the #1 crime in the country. Okay, so they put up guards and they narrow the powers of attorney to be helpful in an emergency, but not potentially devastating. Well, when we get to a situation where we've got to move heaven and earth and shelter maybe several $100,000 or millions of dollars of assets, we have to have those guards down because we need to have greater flexibility. So talking to an attorney who is focused on this end of life planning and the continuum of care and the special needs that a person needs outside of help for a week because they've had a car accident, those powers of attorney are not forms. You don't go online and download a form and treat them all the same. Our power of attorney now is 25 pages long because every few months we see another issue, another case, another court ruling that leads us to know we need to make sure our people voluntarily have the power to deal with an issue. If we don't have that, there's no choice, which is expensive, causes delays, and then gets us back in that situation where we got to file that public report, which can be really, really troublesome. So these are often considered sort of no-brainer, small things. They're all the same. Let me pull one off of line, get mom to sign it, and then we find out that they're probably too little, too late. And the good news is, even if you hire a pro to do one the right way, they're not very expensive. Okay. Important death planning tools. I had a call from someone the other day who told me he wanted to have a living will. Okay, that's great. Well, in Virginia, we haven't used the phrase living will for about 30 years. Why? Because it's really confusing. You know, a living will, when it was first created, was a document. I want to tell you what my will is while I'm living if I have a terminal condition and my death is imminent, right? Well, that makes a lot of sense. And at that same time, of course, for hundreds of years, the essential death planning tool was called a will, a last will and testament. So for a few years there, this is in the late 80s, we had people saying, I've got a will, a last will and testament, which only deals with things after I'm dead, literally, only after death. But now I've got this other thing called a living will that only deals with things before I'm dead. And one is probably financial and the other is healthcare. That's a little confusing. And then all the estate planning lawyers started telling people, well, you should avoid the probate process and you should use something called a living trust, a revocable living trust. Okay, well, I'm here to tell you that if you gather a room of lawyers, if you got judges across America in a room and you ask them to write down on a piece of paper and tell you the difference between a last will and testament, a living will, and a living trust, a majority of them wouldn't even have a clue. Imagine the general public who's not supposed to be trained in these distinctions. This is really very, very confusing. So we have fortunately stopped using the phrase living will. Not all states are that way, but in Virginia, we call them advanced medical directives. And they are, it's not a sexy name, but it is your statement in advance to your medical care providers, directing them as to what you want to have happen under certain conditions. A living trust is a tool that is intended to have the benefits of a last will and testament in terms of providing direction to your family after you die without them having to go through the probate process. And that's a benefit alone right there. But for those of us dealing with caregivers or who are caregivers or with people who have issues and on this continuum of care change, a revocable living trust can be a lifesaver in terms of efficiency and time saving, because our client can put their assets into the trust. They can be their own trustee during their lifetime. It may be in force for 40 years, where they do everything on their own. Nobody else can stick their nose in it. They don't have to file paperwork with the court. But if they become disabled, family members or a person they designate can step in and handle things for them when they're alive. Then when they pass away, the trust moves to a different phase, and then it acts kind of like a will, and we distribute. I don't want to go without saying the value of avoiding the probate process at death, which is the benefit of the trust structure. It's really hard to overemphasize how helpful that would be. We've handled hundreds of estates over 35 years. It is very, very unusual for a formal will and trust state administration to take less than a year. I've seen them go on multiple years. Let me tell you about my mom's estate administration when she died with a revocable living trust. My mom had Parkinson's disease. I created a revocable living trust for her. For years, she was her own boss. She made her own decisions. As she became slower, she asked me to help her with balancing the checkbook, eventually taking over, writing the checks, paying her bills, reporting to her. She died on a Wednesday. I was done with the administration of her financial affairs the next Thursday. 8 days, literally. You can't get an appointment with the clerk to record the will to start a probate in 8 days in any jurisdiction that I'm aware of. So these used to be considered sort of rich person's tools, fancy things. You know what? If you got more than $50,000, it's probably a good idea. And if you have a care concern, if you're on that continuum of declining health, it is really almost a no-brainer because it's not only helps you, but it is a merciful help to your caregiver or whoever is helping you, because they don't have to go fight with the bank about the power of attorney, which used to be I'd send people into the bank, 5 minutes later, they'd come out with a check they needed to pay a bill. Now, minimum, turn it in, it gets sent to the corporate office in Cincinnati, 5 days for them to inspect it. We've seen cases where it's been 9 months to get an institution to respect a power of attorney. Why would they treat a trust better than a will? Because a power of attorney is acting as if they are the principal. Under a trust, a trustee is acting kind of like the president of a company. A president of the company, all the stuff that happens in the company is up to the company. The only thing the bank needs to know is who has signature. But when a bank acts on a power of attorney, you can take their life savings and make it disappear. And what's happening is banks and financial institutions are being sued by people who said, well, that was fraud, or that was a theft, or that was unduly procured. And while they like to say they serve you, that's their main reason for existing. Their number one motivation is to make sure they don't get sued. So this is why people are seeing these big delays. And we can just simply avoid the problem by using a revocable living trust. It helps them and because it helps us. Okay, fact number 7. Let's talk about resources that we can bring on board to help people as they advance through this continuum of care. The first one that I want to talk to is a really cool benefit for wartime veterans and their surviving spouses called VA Aid and Attendance. To be clear, this is not a benefit for people who were disabled during service. There is a thing called service-connected disability that provides benefits. That's an entirely different program, all right? You may have served your time and come out of the service perfectly healthy, but this program is designed to act kind of like the GI Bill. It's a thank you to people who served the country during a period of wartime and their surviving spouses to help them as they age if they need help and they are losing the money that they make that should be spent on their food and the roof over their head. If they're having to divert that to caregivers, and you guys need to pay attention to this, those of you who are caregivers, because you can be the beneficiaries of these funds. The purpose of this program is to replenish that income so that people can have their needs, have their food, and have the roof over their head, and still pay for the caregivers, okay? Nobody's getting rich. The benefit ranges from about $1,500 to about $3,500 a month, depending on the personal situation, whether I've got a vet, 2 vets, or if I'm just talking about the surviving spouse. But let me give you some details here. So this program has a service eligibility requirement, a medical eligibility requirement, and financial eligibility requirement. Service eligibility means that the veteran served for today's generation. This is the rule. There is a more modern rule that's going to become effective over the next 20 years probably. Did our vet serve 90 days on active duty, 1 day during a period of wartime, and was not dishonorably discharged? I'll try to hit these real fast. Active duty is not reserves. It's not basic training. But any advanced training or any service anywhere in the world counts for that 90 days. 1 day during a period of wartime. This is not war as declared by Congress. It's on the list as defined by the VA. The first war on the current list is the Mexican incursion to catch Pancho Villa. I kid you not. That's a war for VA purposes. We have 2 real wars, World War I and World War II. I mean real because they were declared by Congress. We have police actions in conflicts like Korea and Vietnam. And for purposes of this program and several others, America has been at war continuously since 1990 in the war on terror. So if I have 1 day during those periods, that's the next step of eligibility. Note that I did not say that our vet had to have faced the enemy in anger. Our vet could have served her entire tour of duty in Bayonne, New Jersey, which might be more dangerous than Southeast Asia. I don't know. But it's the fact that you were in service and could have been put in harm's way. Last point on service eligibility is you cannot have been dishonorably discharged. Those of us who never served often think there's only 2 kinds, honorable and dishonorable discharge. There's actually a long list. I've seen people with medical discharges, term of service over. There's actually a category called discharge under less than honorable circumstances, which is different than a dishonorable discharge. The only one that's a problem is a dishonorable discharge. That is generally associated with commission of a very serious crime, or more recently, not taking your COVID vaccines. Okay. Medical eligibility became much simpler in the last couple of years. We used to have a very highly technical medical analysis. The new rule is if your patient's, your client's doctor says he or she is not safe, without help, they're medically eligible. You could technically still have a job, drive to work, but if you need help to be safe, you meet the medical eligibility definition. Medical eligibility is defined by the person applying. It could be the veteran. Let's talk about the surviving spouse. How does a surviving spouse get aid? And need to demonstrate that it's these days it's usually a her, but it could be a him, that the spouse's veteran, the spouse who was the service one, met that 90-day with 1 day during wartime requirement, wasn't dishonorably discharged. For the spouse, I have to prove that they were married for 1 year before the veteran died. Remarriage relinks you to a new vet or a new person who's not a vet. So you're going with your last spouse. And for spouses, we need 1 year of marriage before the veteran died. I also want to make sure that you understand that the term veteran is very loosely used under this statute. It's not just members of the Army, Air Force, Navy, Marines, Coast Guard, and now Space Force. There's actually 5 pages of jobs that your client may have performed that helped the country during a period of wartime. Some of them make a little bit of sense, like public health service. They wear uniforms. Merchant Marines, especially during World War II, we got lots and lots of people who were not formally in the armed services, but were merchant Marines. They're included in this benefit. My favorite one is a woman we helped get placed just before COVID. Only uniform she ever wore was as a stewardess for Pan Am, flying planes into Berlin in 1945. The logic was, if the Soviets shot them down, they wanted them to be treated as prisoners of war. So they were wrapped with quasi-military credentials. And even though she was never inducted into any formal service whatsoever, in 2020, I was able to get her enough money to pay for her assisted living and memory care because of her service as a veteran, as a private employee of Pan Am Airlines. That was pretty cool. Okay, financial eligibility is the last one I want to point out here. There are 2 rules. I used to bore people with the technical rules. I'm just going to tell you why they have a rule, and you'll get it. It'll be clear as day. As I mentioned before, this isn't to make people rich. This isn't to help them pass money on to a next generation. It's to make sure that people who are forced to use the money they need to live, their food, their roof over their head, paying their taxes, if they're having to divert that money to care, they're going to have to make a choice. They either get care or food, but they can't have both. So the purpose of this program is to replace that financial loss so that they can have their caregiver. Believe it or not, there is no rule about who that caregiver is. So I can prepare a private caregiver agreement for daughter to provide care for dad. She submits a bill to dad for the reasonable value of the services. She helps him paying his bills and taking him to doctor's appointments or helping him bathe, whatever it is she does to support him, then is balanced against his monthly income. And when he's spending more on care than he makes in regular monthly income, the VA will inject this extra $2,000-3,000 a month into the family. Most of my clients who are caregiver daughters just take that money from the VA and sock it away in an account for dad. They're helping dad because they love him, but now we're building a repository of money that we can use at another phase in the continuum. We used to have a definition about net worth. We had to prove that a person was essentially destitute to get the benefit. New regulations gave us a very clear limit. The number for 2023 is, does our vet have a net worth under $150,000? Many areas in the state of Virginia, you're going to find people that have a very hard time living with a net worth, as you and I think of net worth, of less than $150,000. But because it's a government program, we need to look at what do they mean by VA net worth. VA net worth is not what you think net worth is or what your bank thinks net worth is. It's what the VA says is your net worth. And it doesn't include three very important things. First is your residence, or what was your residence before you moved to assisted living, or the home that you own that you hope you will be able to move back into or into in the future. If you own an interest in your daughter's home, that can be your residence, as well. The second thing that is not included is a vehicle of, actually, they changed the rules on this too. It used to be one automobile. Why they changed the rule, I don't know. The new rule is vehicles. You can own any vehicles you want. So I've taken the position that my client's bass boat was a vehicle because you can get in and go somewhere and we've never been challenged. So you can have a $150,000 RV and as long as you can get in and go somewhere, it fits in an exemption. Now that one's kind of silly. The big tool that we really use is a asset protection trust that's designed to shelter money. As long as we create that at least 3 years before we file for benefits, I can shelter an unlimited amount of money in a trust that's preserved by the family. I could put in 50,000, I could put in 50 million, okay? As long as I do it 3 years before my vet needs care, anything that's in that trust is not counted in VA net worth, okay? So this is a great example of a little knowledge is a dangerous thing. People will see this rule and they go, well, mom doesn't have less than $150,000. I'm going to forget about this benefit and then move on. Okay, fact number 8, we're bearing down on the end here. Many of you all will know that every American is entitled to unlimited long-term care as long as they shelter their assets and protect their families, or if they are broke, the old-fashioned way. This is really important because the crazy high cost of care these days, these are national statistics, 50% of couples and 70% of individuals are impoverished in 1 year. When they need long-term care because these costs are just devastating. It's not because we're irresponsible. I think it's actually because we are responsible people. We pay our obligations as they go. Maybe we help a daughter get to college without student loans, or the roof on the house needs to be replaced. Every month there is a concrete bill to pay, but dealing with long-term care is sort of speculative. I don't know if I'm going to need it, and I don't know when. And as a result, people save less than they really need to. And when that crisis occurs, we find that they're running out of money too fast. So the program that we use that's unlimited is a Medicaid program called ABD. This is different than the health insurance Medicaid program that you hear about associated with Obamacare and the public portal. That is a welfare program designed to help people who have very limited resources and income. ABD is designed to be the third leg in a stool with Social Security and Medicare to make sure people who are disabled or who are seniors are safe. Social Security provides income. Medicare is health insurance. And by the way, are those welfare programs? No. Warren Buffett gets Social Security. Warren Buffett has Medicare. He doesn't need them, but he gets them. Why? Because he paid into the system. There is a third program that's eligible on the same basis called ABD. A stands for aged, B stands for blind, D stands for disabled. So you can be blind or disabled at any age, or if you're over 65 and you need help in the daily course of life, this program can provide care for you. If you check your stub, you'll see that they withdraw from your pay Social Security, right? And they take out something for Medicare and Medicaid. You have paid an equal amount for long-term care that you paid for Medicare health insurance. Virtually nobody knows that. You are funding this on your own, and your employer is matching every single month to go into this. That you don't have to be poor to get it. You will get it if you're poor, What you need to do is to protect your family from this. If you think ahead and say, I don't want my family to become impoverished, you can save your family well. Why would the government allow you to do that? Because it makes great sense. We love our family members and we will go broke for them. Wives will go broke for husbands, husbands will go broke for wives, and children will go broke for parents. And then what happens is we pass impoverishment from generation to generation. And who has to pay for the welfare benefits for that entire family of 6 or 8 people? The government. We do. So it's actually better, more cost effective to cut the cycle of poverty and pay for dad's care up front, giving mom a chance to make it through retirement and the kids a chance to prepare for their own retirement and their own long-term care. It doesn't work if it's not unlimited. Here's what I mean by unlimited. If your mom is in a nursing home in Manhattan where the cost for a private pay is $30,000 a month, they will pay every dollar every month for her to get the care at that Medicaid-approved facility. If your brother broke his neck in a car accident at 20 and needs long-term care for 60 years, they will pay every dollar of every month for 60 years, provided that mom and brother have been made eligible under the rules. The biggest, I think, tool in this that's misunderstood by people, many people think, oh, well, yeah, I understand that there's a program, but it's going to be, and my mom will be in a cardboard box on a metal shelf in the basement of a facility that smells like urine 365 days a year, that's run by the government. Those are all myths. Here in Northern Virginia, I think there's 17 facilities that are Medicaid approved, including the one that most people think is the best one in the area. But I appreciate that no one wants to go to a nursing home. I've never had a client say, Rory, can you help me go to a nursing home? All my clients want to age in place. There's more dignity and independence in their own homes, right? 75% of the people who use ABD in America use it not to go to a nursing home, but to get private care to come into their own homes. They hire and fire the caregivers on their own and use this money to pay the bill. So here's an example real fast. I've changed the names. This is an actual case from our office. I've changed the names to protect the innocent, though. Bob and Jean are my wife's parents' names. Our client, who's using the assumed name Bob, was a farmer. He had a stroke. He was literally found in the field. It was a terrible stroke, devastating. Physically, he was bedbound, but mentally, he was actually very sharp. So he is aware what was going on, but very serious physical limitations. There was no chance at all that he was going to be able to return home. When he had the stroke, they had a family farm worth $3.8 million. They had a beach house in North Carolina worth almost $900,000. They had $150,000 of investments. Jean admitted to being a jewelry hog. She had some nice pieces of jewelry, and she had some antiques from the family worth a couple $100,000. She was also very conscious about this issue of dignity and independence and being in control of her assets. She was not interested in spending this $4 or $5 million down and leaving nothing for herself for retirement or for her children, nor was she interested in turning control of all her assets over to a government agency or to a nursing home to manage for her. What we were able to do was use this ABD program, and the legal tools that we're able to use, we were able to change the definition applying to each of these assets from countable resources to exempt resources. A common myth is that only poor people are entitled to ABD Medicaid because you cannot have more than $2,000 of wealth or assets. That is untrue, okay? If you don't remember anything else from this presentation today, that is not the law. The law is you can't have more than $2,000 of something called countable resources. A countable resource is an asset that is left exposed that a caregiver or a nursing home could come and seize in a lawsuit. But if I shelter them to protect your spouse and your family, the government says, winner, winner, chicken dinner, you've done what we wanted, you've protected your family, keep your $5 million and we will pay for your care. So this is where the elder law lawyer can definitely earn his keep. Home care. You all probably realize this more than anyone else, that home care can be way more expensive than the nursing home. We had a client coming in the other day. They were paying over $40,000 a month for 24-hour care here in Northern Virginia because there were 2 people. And it was just devastating. And they were writing a check for that every single month. I had a meeting a few months ago with the #1 home care providing agency here in Northern Virginia. He told me he couldn't give his mother better than $27 an hour. If he wanted to, we see $35, $45 an hour on a regular basis. Even at $27 an hour for 24 hours a day, that's over $20,000 a month. And I don't know about your parts of the state, but around here, it's pretty hard to find a nursing home that costs more than $20,000 a month. The other consequence is, of course, that when people try to save on this home care by providing the care themselves, we create a situation in the prison. The person who needs the care is in prison, can never get out and go anywhere because the world needs to be constrained to keep him or her safe. But the warden, the caregiver, is locked in the prison too. The warden can't go home because the warden needs to stay there 24 hours a day to keep the inmate safe. And this creates burnout, which creates unsafe situations. I won't mind telling you about a case that came to us recently where it was reported to us that in order to keep her mother safe, who was a cognitive decline wander risk, daughter was locking her in her bedroom at night, had reversed the door to put the lock on the outside in a 3-story townhouse. This woman was a fall risk, Alzheimer's. If that house had caught on fire, there was 0 chance mom was going to be able to, make it out alive. Why would that be a rational thing to do to anybody? Well, when you haven't slept for 5 days, you'll do just about anything, to be able to get some sleep. So trying to find a way to bring in some resources like the ABD can be really helpful. ABD as a default around here will pay for, up to 8 hours a day, 7 days a week. That can allow a person to go to work, go to church, go to the grocery store, and even if they want to be fully committed to providing a major part of the care the rest of the day, it can provide enough break to avoid the caregiver burnout. Okay, so what I want to talk about here is how I think it happens that people end up in situations where they're spending too much in a situation because they make an assumption that it's actually going to be the least expensive way. And there's a disconnect in this continuum of care that you all probably know instinctively, and maybe this will just be a sort of a good way of articulating it. All of our loved ones who are going through this care continuum are facing a functional limitation continuum. We all have no limitations. We may start with limited ones. We move to the walker or maybe to the wheelchair on the path towards death. That is to say, the trend seems to go in one direction. We may go up and down along the way, but we all know where the train is going. Well, how do we live? Well, there's also tends to be a continuum there. We're living at home, running triathlons. Maybe we bring in a little assistance or a spouse provides some assistance. Maybe some folks move to a 65 and over community. You all know about assisted living, memory care, and nursing homes. And these are all viewed as sort of increasingly geared towards functional limitations. But also, you're all going to admit that everybody realizes, or everybody fears, that there is less dignity and independence the farther you get down the right? So there is a desire to stay at home, where we've already talked about the fact that could actually be more expensive. And we have to balance or marshal our assets and use our dollars to get the best out of each place of living. Met with a client yesterday where we've decided that because we can project the quality of care necessary in the future is likely to be a nursing home, we can bring on ABD benefits to pay for that for virtually free. That will allow us to use dollars liberally now to pay for care while the person is still relatively independent, knowing that we will someday move to a different residential situation, but we'll be able to bring different benefits on. In fact, in that situation, we're going to move from home, where they'll privately pay, to assisted living, where VA benefits will provide several $1,000s of relief a month, all the way up to nursing home care, which will be, for this particular client, absolutely free with no copay. What I'm trying to say here is that it's important that to accurately link where people are on those continuums, you need to have more information than just one of us. The caregiver doesn't necessarily know the legal tools and the solutions, doesn't necessarily know the benefits. The lawyer doesn't necessarily know how to accurately predict how fast a person is going to proceed down the continuum. The benefit specialist doesn't know what the caregiver knows, and doesn't necessarily know what the lawyer knows about what can be brought on board in a year or two. So this multidisciplinary approach, this holistic approach, is starting to become a more popular thing. Some folks call it a life care plan. We call it care coordination in combination with the law. But what it does is it tries to bring in financial help for paying bills, sorting through EOBs, reconciling them to make sure people aren't overpaying if they've had a visit in the hospital, with the legal strategy or construct to help deal with the continuum of care, but having in-house the social worker or the registered nurse who can provide care oversight, warnings to people that a house is unsafe. How many of you have seen people who have a tendency towards hoarding? Had a guy last week who had those boxes that you put clothes in when you move, that they're this tall and you have hangers in them, right? He had 5 of them with nothing but hangers, like that you get from the store when you buy pants. And I'm like, why do you need 5 boxes of hangers? Well, you never know. I might need them. Well, do you think we could get by with 1 box? Because you've got like 50 in the 1 box. Well, let's talk about that. We've seen our caregivers gone into homes seeing extension cords stretched across the top of the staircase, all kinds of these crazy things. You guys could tell me more stories than I'm sure any of us, really want to hear. The point here is the better that we can work together to help make sure each of us as providers know about the tools that the other uses. We can make life better for the person who needs care, and we can make life better for the caregiver who may become overwhelmed. We like to say what we're trying to do is return the caregiver to what they do best, which is love and support, and take off the heavy lifting like paying bills or being trustee or worrying about the legal documents or coordinating who's going to clean the house or make sure mom gets to her doctor's appointment. We provide relief for that, sometimes plugging into these benefit programs, including long-term care insurance. So I'm not going to go through this slide as sort of an introduction about us and me. Juliana did a really great job of describing who we are. But I wanted to, in closing, tell you that all of these points that I'm conveying to you today come not only from the perspective of me as a lawyer who's been doing this for 35 years, but I've walked this journey myself And I understand, and people who want to be effective at this need to understand that this isn't rules on pieces of paper. This is the intersection of humanity with personal goals and priorities and desires, and a desire for dignity and independence. And the law is just a tool. The knowing how this plays out, not only for the person with the need, but for the caregiver, is crucial to getting a quality outcome. My journey involved these people. This is my mom. She had Parkinson's disease for 14 years. We were able to keep her at home for 12 of those 14 years. Nobody wants to go to a nursing home, least of all my family wanting to send mom. But finally, her doctor just said she couldn't be safe. She needed multiple caregivers around the clock in order to be safe. And we had to recognize that we were being irresponsible if we tried to keep her at home any longer. This is a picture I took of her the day she moved in to her nursing home. You'll see those cubby holes in the back. This is a picture I took the same day of my dad. That's the day he moved to assisted living during his 11-year journey with Alzheimer's. He eventually went from independent living to assisted living to memory care. Last two people I want to tell you about are my two sons. The picture on the left is my son, Justin. He's now 28 years old. Justin has autism. He's doing great. He's moved out recently and living independently. He has gotten into the Steam Fitters Union apprenticeship program. He's learning to be a welder. He still has challenges, but he is doing really, really great, and I'm very excited about it. This is a picture of when he graduated from high school at 22, something for many years we didn't think was going to be even a remote possibility. Picture on the right is my son, my other son, the opera singer. That's him standing on the stage in Prague at the theater where Mozart debuted Don Giovanni. My son was Don Giovanni last summer in Prague. Scotty is totally blind in his left eye from an autoimmune disorder, and his right eye is under attack. Unfortunately, I was with him last week when his second doctor told him he needs to plan on when he will be totally blind, not if he will be totally blind. He's got a pretty good attitude. He said it didn't hold Ray Charles or Stevie Wonder back. He's prepared to try to advance in his life, knowing he's going to have that challenge. My point here is to tell you that, is to emphasize this point. You all know this. The law in elder law and special needs law is a tool. Understanding the family situation, the resources of every family situation. Do I have a 98-year-old woman who has no one? Do I have an 80-year-old woman who has a daughter in Oregon who can visit once a year? Or do I have a 90-year-old man who's got 6 children in the same county and 28 grandchildren, and he's getting visitors every day, right? These personal resources. Do I have a oldest son who lives in Atlanta who insists that every decision has to be passed by him because he has the right genitals and he's a boy, he's the oldest? I see it every week. Do I have a situation where the oldest daughter is the primary caregiver because that's the way it works? And I can tell you in my family that gets inherited. My oldest sister has died from colon cancer when she was younger than me. And the role of oldest daughter got passed to my other sister, who's actually in the middle, but she was now the oldest daughter. And so somehow nature, takes its course. Understanding these realities in the world and helping people balance their personal resources, their financial resources, their benefits, the strategies that are available to them, and understanding the challenges, the people who are not necessarily there to help, but maybe got their own personal agendas, to combine a solution to keep people on this path of control, dignity, and independence is why you're going to start seeing these multidisciplinary practices come about. Okay, so I think I'm coming in at about an hour. I don't know how long you guys have to ask questions, but I am open for it. I just want to thank you all for giving me an opportunity to give you my presentation. I enjoyed it, and I hope you all learned something.
Yes, thank you so much. That was super, super informative. Did anybody have any quick questions? I know we're coming towards the end of the hour, but any quick things that maybe anyone was wanting to ask before we close out?
Yeah, I do.
Yeah, Nick, go ahead.
In regards to the ABD and essentially moving countable assets to no longer be countable, are you referring to irrevocable trusts and supplemental needs trusts?
Well, that is one tool, one way to do it. That is the simplest, most proactive way. So what Nick is talking about is something called a Veterans Asset Protection Trust or a Medicaid Asset Protection Trust. By law, anything we put into one of those trusts is no longer a countable resource. Now, making the gift of the asset into the trust may create a different problem called a transfer, but it is at least a non-countable resource. Here's the good news. That is one of probably 18 tools that we can use to shelter assets or make them non-countable. And here's the key part. To avoid a transfer penalty by using a trust, you have to do it 5 years before you file. Everybody's heard of the look back. Of those 18 tools I use, that's the only one that requires advance planning. The other 17, the ones we used for Bob and Jean, we didn't use a trust to get Bob qualified. I moved about $5 million from the from the countable resource category to the exempt or non-countable resource category, and we did it in 3 weeks. But we had to use other tools. If any, you all probably, well, some of you have looked at the Medicaid manual, you know, it's 7 volumes long, but buried in there are little kernels of gold, each one associated with specific kinds of assets that people have, where we have special policy reasons why we may want to, as a society, protect them. For example, the reason I was able to protect that $3.8 million farm for Bob was because that's where Jean lived. If we made Jean sell her home, she would be on the path to poverty. So we moved the house simply from Bob to Jean, and it was now exempt. $3.8 million or $5 million disappeared with me recording a deed for $35. That's an example of the kind of thing that we, that we do. If I'm going to stop sharing and reshare something else, here we go. That is a great way I describe it to people. Can you all see this? You remember this toy from when you were a little kid? Okay, inside is sheltered, inside is exempt. I don't have to, and outside those yellow things, those are your assets. I do not have to spend them, throw them away, give them to the government or give them to the nursing home. All I have to do is get them inside the toy. And so what you may do is bring me a hexagon and I squish it and shape it into a pentagon, and then I can get it into the toy and it's protected. So what I really do is sort of transform ownership of things without squandering them. Make sense?
Yes.
Anything else?
Let's say any other questions? Awesome.
That means I've either bored people to death or I'm rushing them into lunch.
No, that was super interesting. I think I learned a lot. Now I'm thinking I need to start having a conversation with my parents about the future and how we're moving forward with all this. So personally, thank you, but also thank you from the VCC for being here today and sharing this incredible information with us. And yeah, so if nobody has any further questions, I just want to please remind everyone to fill out the survey. It's in the chat. Please fill it out. You know, again, we are looking for that feedback on our educational sessions, just to learn more about how we, you know, can improve it, what other topics you guys want to hear more about. And so, yeah, please just take a moment to fill that out. And we hoped that we'll see you at all of the rest of our meetings for 2023. There are hyperlinks for the Zoom registration for all of the year's meetings at the bottom of each meeting flyer that goes out, and on the meeting schedule that is sent out with it. So you can go ahead and just register for all of them for the calendar year if you want to. And we hope that we will see you all at our next meeting in July.
Okay.
Thank you very much.
All right, thank you. All right, bye, everybody.
Bye.
Thank you.